Good evening, everybody. I think my computer's a little bit delayed. So I'm having some technical difficulty. But I'm going to wait a few minutes, not really minutes, but just a couple of seconds for some people to start tuning in. I see someone has already started posing questions. Tonight, this is a live Q&A for family law questions. So that's questions pertaining to divorce, child support, custody, etc. If you ask the question, I'll go ahead and answer it for you. So just make sure you go ahead and type it down below, and I will get to it in the order that it is posted. A little bit about myself. My name is Attorney Joy Farrell. I'm the managing attorney of the Farrell firm located in Tucker, Georgia. Our specialty is family law. So if you have any family law issues, feel free to contact us or look us up. You can find us online at atlantacustodylawyers.com, and on there you'll have our contact information. So I'm going to go ahead and get started. I'm going to try to be live about 30 minutes, so try to get all your questions in during that time frame. Type them below, and I'm going to go ahead and get started with what we have. So our first question is from Miss Etheridge, and she says, let me get my screen clear. Okay. She says, what happens if the non-custodial parent and custodial parent plan to speak with a mediator to try to avoid court after disagreements already between custodial parent and non-custodial parent idea of parenting plans with a lawyer, and they don't come to an agreement? Will they have to go to the court as a result, or will there be a decision made for standard visitation? Okay, so that's a good question. Good try for trying to go to mediation to resolve it short of court. But if there is no agreement, then you do have to go to court. Standard visitation, I was just talking to someone about this today, has been kind of cornered into this every other weekend plan, but that's really not standard. The parenting plan, when we talk about every other weekend, that is the minimal amount of visitation that someone will be ordered. So it's not standard. There really is no standard, and you should seek for a court to ensure a customized parenting plan that works for your life and the other parent's life as well as the child. So you have to have a hearing, and you have to present your case to the judge as to what you want to be ordered for the custody. This is a follow-up from her. I've heard in Alabama, standard visits don't have any overnight until the age of 5. I've tried to find Georgia's, but it still appears we don't have a standard visits for the state, just certain counties. Is that correct? Right. That's terrible if that is the law in Alabama, that overnight visits don't take place to 5. I find that to be inappropriate, quite frankly. But Georgia does not have a rule like that. Again, we don't have standard visitation. We have minimal visitation, which is every other weekend and alternating holidays. If you're going to court, you need to possibly get a lawyer, or at a minimum do a consultation so you can find out what your chances are for getting what you want. Could the judge possibly make a mother stop breastfeeding in order for there to be overnight visits sooner than desired expected? If so, could the mother fight this? When we have young children, sometimes that is the issue with breastfeeding. I would encourage you or the mother to start trying to bottle feed the baby with the breast milk, given that when child starts daycare or school or whatever, they will have to use the bottle. Babies who have to start daycare at 6 weeks because their parents have to go to work have to eat from a bottle. That's the only way they're going to eat. And so breastfeeding isn't as strong of an argument as it used to be as we kind of proceed forward in modern times. So yes, a judge could order overnight visits, although you are breastfeeding your child. However, some judges are more traditional and will definitely wait that time frame. Okay, you're saying he's 2, he doesn't bottle feed. So breastfeeding should not be an issue for you. And then you follow up and say, so a lawyer isn't needed for mediation. I would definitely have a lawyer for mediation, because you could get a final agreement, and that agreement becomes an order of the court. So once the mediation is done, a lot of people come back and say, well, I just want to check what I agreed to. Is this good? Is that good? And if it's not, then there's nothing you can do to change it. So you should definitely have a lawyer at the time of mediation. Okay, Starks says, I'm filing for divorce from my wife, and she had been taking money out of our joint account where her direct deposit goes and put it in her separate account, which I don't have access to. She is the breadwinner. Can I subpoena her to have access to that money since that money was used for household bills? Good question, Mr. Starks. You can subpoena that information once the divorce is filed. Any money earned during the marriage is marital property, regardless of if it is in your account, her account, or a joint account. Those assets are marital property, and they would have to be divided accordingly. Okay. Delise, she contacted our office. Our cost is too high, but my court date is right around the corner. I'm the one that has 2 kids, non-custodial, make over $250,000, and I make less than $25,000, and he only gives me $1,000. Okay. I remember exactly who you are because that was very shocking. Do you have a question for me tonight? I'm going to highly encourage that you do whatever you need to do to get a lawyer, because this is how I have to spell it out for people sometimes, Delise. So you're talking about he wants to give you $1,000, right? And you could say should be getting maybe $2,200 a month. So you're talking about getting an extra $13,000 roughly per year for however old your kids are. Let's say for the next 10 years. So you're talking about $130,000 more in child support, and you don't want to make a $3,500 or $5,000 investment in a law firm. It just doesn't make sense. I mean, it's an easy return on your investment. So I would encourage you to get representation to make sure that you get the proper support that you should have. Golden says, how can my husband get visitation for his kid that lives in Florida? He will probably have to take that up in Florida. If the children's home state is Florida, then that has jurisdiction. So he would have to file a case in Florida. Okay, follow up from Delise. He is not turning any paperwork to child support and is claiming he quit his job last week. Of course. Can I just pay for advice on how to go about this? Would that be cheaper than representation? He claims he has a plan that will require him to pay me less than $1,000. You should come in for a consultation and we can run some numbers for you. That's ridiculous. It's convenient he quit his job. But a little tidbit here. So a lot of times people quit their jobs in an effort to avoid paying more child support. But if you watch, I think it's a video I have on the page called Child Support Part 1. I discuss in detail about the different ways we impute income. Imputing income meaning you're not making the income now, but we impute it at a certain rate. And your earning history or earning potential are figures that the court can use to calculate child support. So if he quit his job last week, then by all means, I would go into court and ask for the court to use his income of $250,000. Achita, do you know how long it would take if they have to go to court after mediation? What county are you in? Usually you can get a court date, well, if you don't have lawyers, I don't know how y'all go about getting a court date, but lawyers, we can get a court date usually, probably in about 2 months, roughly, depending on the judge. My daughter's father is trying to get legitimized. I haven't gotten served papers yet. How long does it usually take to get served papers? That's going to depend on the county, but if they're doing service by sheriff, it could probably take maybe 1 to 2 weeks, unless they're trying to serve you when you're not home. But if they are trying to serve you and you're not there, they'll leave a notice at your door for you. So it doesn't take long. You can always go to the county website of the court, of the county that you live in, and type it in and see if he's filed anything. A lot of people say they're going to file stuff and they actually don't. So he may not have filed anything, but you can check. Okay. Oh, okay. Fulton County. Fulton doesn't take long. They pretty much have you come to court almost, sorry, that's my dryer. They pretty much have you come to court almost every 30 days. So once you get to that 90-day status conference, you should tell them that you want a hearing on a matter. Then they'll go ahead and get you scheduled for a final hearing. Mr. Stark says, I'm currently on child support for one son that is not by my wife, who will not let him come to our house. Can this affect her custody of our 3 kids during divorce? I don't understand. Are you saying you're paying child support for a child that's not yours? Help me understand that. Lawyers and budget hard to find, but Fulton. Yeah, lawyers aren't cheap. I can't lie. You can check legal aid, or you can. We have a lot of videos on our website. On our website and on our Facebook page to try to help guide people who can't afford counsel. So maybe you can go there and try to find some answers, or continue to ask your questions on here. I totally don't mind answering them to help you out. Is it possible for someone to get a consultation even if they aren't able to afford representation? Absolutely. Most people consult with us, and some hire, some don't. Some people can't afford it, but you still walk away with the information. The information you get in the consultation is invaluable because it's very specific to your case. So yes, people do that all the time. Okay. I think I skipped a question by accident. Okay, Delise says he works under subcontractors and child support says they can't track it, but he's in the IT field. Okay, Delise, let me tell you this. So yes, if he is a contractor, he's not in the Department of Labor, which means when Child Support Services pull his Department of Labor records, he's coming up looking like he's unemployed. All right, so you super duper, I would probably dismiss that child support case because otherwise they're going to put him in at minimum wage and he's going to pay you well under $1,000. You need to file a private child support action so that you can have lawyers who are going to subpoena his bank records and his financial history to uncover that money. Otherwise, you're not going to get anything. And then once the child support goes in, you can only modify it if there's a change in circumstance. And him lying isn't one of those things. So I would not move forward with that case based on what you're saying. But again, before you do that, I'm going to encourage you to probably come in for a consult. Golden, they say he have to get a lawyer for the case because they were divorced without joint custody. So that's when wrong for him. I may need your... Okay, I'm not understanding. Let's see. Hold on. Let me go back to your initial question. Okay, this is about the Florida case. Okay, I got you. Okay. They shouldn't have let him get divorced without addressing custody. That's required in Georgia. And so what he would have to file in Florida is a petition to establish custody if that wasn't established in the divorce. Okay, he is mine. Okay, so you have a child by another woman that you pay child support for. Got it. No, that will not affect the case with your wife at all. Okay, Achita. If child support is modified, how long does it take to become valid or finalized? And so I say this too in my child support videos. The only way to modify child support is actually going through the courts, like side agreements, notarized statements, text message agreements. That does not qualify as a modification, and you should not do it because you can get in a lot of trouble doing that financially. So you would need to file a modification of child support, and then once you go through the process of the courts, it'll be finalized. The modification statute says the courts are supposed to hear those cases as soon as possible. So depending on which county you're in, it may be heard in 3 months. It may be heard in 6 months. Okay, I see you're saying you have a court date. Awesome. So once you go to court, you'll probably get a ruling that day. Taylor, I had my child before getting married. Do I still have to have a parenting plan before filing for an uncontested divorce? Taylor, if you married the father of your child, then that child is now legitimated. And if you're doing an uncontested divorce and he is the father, your husband is the father of your child, then yes, you need to have a parenting plan filed in along with your uncontested divorce. And you're also going to need a child support worksheet and a child support addendum in order for the court to grant that divorce. Trevenia, if you lose your parental rights, do you have a chance of ever regaining custody? If your parental rights are terminated, no. If you just don't have custody, like you have some type of visitation, then yes. But a termination of parental rights, that's a permanent thing. Okay, Achita, you're saying it's a temporary order currently. Okay, cool. So you got a final hearing coming up. You should get a ruling that day, ideally. That's okay, y'all. I know y'all got typos because y'all typing fast. It's okay, I got you. He has filed to legitimize, but I haven't got served yet. I'm never home. I'm always working. So how many attempts will the sheriff make before giving up? Usually most sheriff's departments make 4 attempts before giving up, but if he pays them again, they'll do 4 more attempts. What he should really do is probably hire a private process server to have you serve, or if you already know the papers are filed, you know the situation is coming, you could go ahead and do what's called Acknowledgement of Service, like go down there and get a copy of the papers or tell him to give them to you. Then he doesn't have to like find you at your job and give you the papers. You can just file it in saying you have a copy of the papers, and then the process will get started. And because you know it's filed and he's not been able to serve you, you definitely want to be watching the court website to make sure they're not trying to serve you by publication or enter an order without your knowledge by saying like, oh, we couldn't find her or she disappeared. So, they just go to court without you and get whatever they want. So you want to keep your eye on that. Demax says, can you move to a new state legally if you are the primary custodial parent and the non-custodial parent is locked up in jail serving time? Absolutely. It's funny, the office is on. Hey, Jeffney. Jeffney, Attorney Roy, she had a baby this week, so she's out and she's tuning in. Hey, girl, hey. Okay. Delise, is it possible if I come in for my consultation before March 19th? Sure, you can come in tomorrow. Call in the morning. We open at 9. We can get you on the calendar. We have availability. Achita, should I go to the court date even if not required? Yes, you should. I don't know why you would not be required to go to a temporary hearing. Oh, unless it's child support services, they do say stuff like you don't have to come, but I would always go to any hearing that my name is on if I were you, because then they'll enter an order and then you don't know anything about it. You can at least make your objections if you have any. Desmond says, I have joint custody of my son. He lives between both homes equally. Do I have to pay his mother child support? Sometimes, Desmond, it's going to depend on the income breakdown of you and his mother. If you make more income than her, much more, like a larger disparity, then you may have a smaller amount of child support. If you guys kind of make similar money, child support will probably even itself out. Just because a child lives between both homes, that doesn't necessarily mean one parent doesn't pay child support. If one parent makes $30,000 and the other parent makes $95,000, the parent that makes $95,000 is still going to have to pay the other parent some type of financial support. So it depends, to answer your question. Achita, girl, I am not mad at you. You are getting your questions in. Is it possible for a custodial parent and maybe a non-custodial parent to get a parenting plan in place without legitimizing but allowing parental rights? No, it is not. You guys can agree to whatever you want to, but it doesn't mean anything. It's not enforceable. So, no. Okay, Princess, if you have primary custody of a child and the father has visitation rights, can I move to another state? You should be able to move, yes. Your order will dictate that. Typically, what Georgia court orders say is that you have to give like a 30-day or a 60-day notice. So read your parenting plan and your final order to let you know what the situation is. Typically what's going to happen though, even if you can move, as soon as you notify the father that you are moving, he's going to file a modification of visitation or custody or something to try to prevent that move. So you should be prepared for that to happen. Okay. Erica, if non-custodial parent has a warrant out for non-child support and the sheriff has come to one address but they don't stay there anymore, how do they find them? They're not going to do anything to find them. It's really going to be up to you to locate them, honestly. So you may want to either invest in a private investigator or tip them off. They're not going to look for them. I know it sounds like, oh, there's a warrant, but you're not. Okay. Is it too late to stop the child support order from going through, even though my paperwork is already turned in and the court date is in place? No, you can dismiss it if you want to, but talk to us before you do that, okay? Kenyatta, I have it's covering up my face here, okay? I have my children's father, son, that's not living with me. The mother is deceased and the father live in another state due to some probation stuff, but he wrote me a letter that was notarized telling me I have active custody to do for him. I want to try to adopt him or get some kind of legal custody. How do I go about doing that? Me and the father are engaged. I have my children, father, son. Okay, so you have your child's father, son that is not your child. His mother is deceased. You want to adopt him. Yes, if dad, the father, terminates his parental rights voluntarily, you can go forward with adopting the child. In the meantime, if you want to do something faster and cheaper, he can sign over temporary guardianship to you. And that will be good forever until he cancels it. So that's another option for you. Is there a way to cancel a legitimation if custodial parent plans to get married and wants adoption name change available from step parent? No, only the dad can choose to cancel a legitimation action. And it is very normal, and our statute allows for a father to request the name of the child to be changed to his name in a legitimation action. However, his wife will not be able to adopt the child. Princess is following up from her question about relocating. Do I move first? I have to notify him. No, you have to notify him. You don't have to notify the court, but you do need to send him written notice. I would do it by email. Erica, what if I ask for another court date? They're probably not gonna give it to you. You can try. Cheetah says, should a parenting plan be based off the non-custodial parent or custodial parent county? Parenting plan doesn't matter where either parent lives. If you're talking about filing the case, it should be in the county where the custodial parent lives. I hope I'm answering your question about that. Okay, what is the soonest you can make a change to a plan? Child becomes school age, things change. The standard time frame is a 2-year wait time, but with custody, anytime, the statute says anytime there is a material change in circumstance that affects the well-being or the care of the child, you can file for a modification of custody. So if something happens, you can file for a modification. Non-custodial parent wants name change. Custodial parent does not. That's why there's so many legitimation questions. Okay, yeah, well, that's totally normal, this situation here. Most custodial parents don't want the name to change. It's going to really depend on how old the child is. If the child is young, I would expect the name to change. And with which the custodial parent should ask for is to hyphenate the name. So, like my last name is Farrell. So if I had a child, I would say, okay, well, I want the name to be Smith Farrell or Farrell Smith. So my name would still be on it, but the court is likely going to change the name unless the child is much older. Okay, I see what you're saying, Achita. You're asking about the which county it goes off because breaks are different. So in your parenting plan, you're going to want to put that. Even if the parties move, you're going to want to say, we're going to follow the schedule of the school district where the child attends. So if the child goes to Fulton County schools, that's what's going to take precedent. If it's DeKalb County, that's going to take precedent. And so just have that language in your parenting plan, you'll be good. Chantel says, if a deposition is scheduled, is it illegal if a person does not show up? You can be sanctioned. I mean, you're not going to go to jail, but you can be sanctioned for not showing up for a deposition. Okay, Cheetah, the child is 2, then yeah, that name is probably going to change. Torrance says, can a spouse force you out of the house if both of your names are on the lease? No, they cannot. If you are married, you cannot evict your spouse. So get comfortable. Stay there. Yes, even if non-custodial parent is married, that name can change. Yeah. Okay, this is a big question. My son's father and I did a voluntary child support agreement. However, my son's father and I are having difficulties co-parenting. He now wants to take me to court. I wish him no ill will. However, I want to be sure that I have full legal and physical custody of my son. I believe his father's discipline tactics are too harsh. For example, telling my son if he doesn't move his hand off an object that he's going to break his hand and proceed to squeeze his hand too tightly. He's only 4 years old. What can I do? Thanks. Well, he needs to, he said he wants to take you to court. Well, he needs to take you to court first. That'll be the first step. He needs to file a legitimation action. And then once he files that, you should probably get a lawyer and respond and come up with something that you're going to be comfortable with and make your arguments to the court about his discipline tactics and let the judge decide, or see if you guys can come up with some type of agreement about that. She says custodial parent mom doesn't want non-custodial parent married name to child. So the non-custodial parent would be the man, assuming, unless this is a same-sex situation. But the non-custodial parent, if it's the father, and if it's a legitimation action, he can change the name. And your next question is there a way to change it back? That child can change their name when they become an adult, if they want to change it back. So I think, if non-custodial parent is asking for visitation in the parenting plan, but I have a protection order against his live-in girlfriend, how does that work? So our Rudy list, you should see if the protection order is for your child or just for you. If it's for you, it has nothing to do with your child, and the child is permitted to be around the live-in girlfriend. I'm sorry, Achita. I don't want to lie to you, girl. Just telling you the truth. Okay, so I think I've hit on my questions. I'll give you a few more seconds just in case some of you guys are typing. Will the judge ask the child where he wants to be, even if he is young as 4 years old? Absolutely not. No. My 4-year-old says she don't want to live with me sometimes. She want to live outside, she said. If non-custodial parent and custodial parent were never married, child is not legitimized, and non-custodial parent has barely been present but occasionally asked for visitation, are there any programs that you can recommend to help non-custodial parent with parenting education? I like my child to have a father, but he hasn't filed for visitation or legitimation. I know he won't file because he hates courts. Lauren, that is unfortunate because We can make non-custodial parents support their children financially, but we cannot force them to be in their children's life. It is a right and not an obligation. So there is really nothing in place that can be done. Now, the courts do offer parenting classes for those pending actions to assist parents with co-parenting. But if he doesn't want anything to do with courts, he's not going to go voluntarily sign up for this class, and he's not going to follow legitimation, and that is unfortunate. Okay. Abandonment. Why are we talking about abandonment now, Cheetah? You losing me now, girl. You're trying to come with anything not to change that name. The name is changing. Tell me what you're talking about now. Okay, non-custodial parent was ghost until child support placed for testing. Girl, join the club. A lot of people are ghosts until they start coming for those coins and they have to pay that child support. They're going to say, okay, well, if I'm paying child support, I want to see my child. It happens every time. Every time. You're welcome, Lauren. What happens if abandonment does occur as far as custody and visitation? Can the parents still agree to plan? Yeah. Cheetah, you're funny. Okay. I got you. I follow. Okay, so any other questions, guys? I'm going to go ahead and throw my number up here. You can reach our office at 678-973-2803. You can find us online at atlantacustodylawyers.com. You can book an appointment directly through our website if you would like to book tonight. Otherwise, give us a call tomorrow. I will be going live next week on Friday, and I plan to discuss parenting plans and how you can better understand them. So tune in for that. And otherwise, in between time, hit us in our inbox if you have any questions or need advice on how to hire us or anything like that. Hope you guys have a wonderful night, and I really appreciate you guys for tuning in and sharing this broadcast with your friends.